Yesterday, your lordships are directed. Well, I'm sorry, my lord. With reference to item number 10, there were two matters which I mentioned yesterday. Your lordships are directed those matters to be taken up along with item number 10
no
today.
problem. All matters will, because the point is the same.
My lord, we had given a letter to the registrar also.
Yeah, no difficulty. Everything will be listed.
But it has not been shown in the list today.
Makes no difference. You are here.
All right.
Lordship,
It will be taken up.
Lordship, I may be allowed to.
Get proofs are not there, therefore they couldn't list it under the.
Your Lordship, I may be allowed to.
Yes, sir.
Lordship, I may be allowed to mention one matter, Your Lordship. It is the original suit of 96, Your Lordship. No, Your Lordship, it was moved, Your Lordship, but it was.
Send me an email. I'll pass necessary administrative direction.
Please, Your Lordship.
Sorry, tax we will take after this. The moment West Bengal gets over, we will take a start the tax. Yes.
May I place it on behalf of the state? There's the SLP 9586.
Yes.
So myself and Mr. Colbler, we are appearing for the state of West Bengal.
It will be 10.1.
Yeah, 9586.
Yeah.
So broadly, in this group of matters, there are two separate aspects involved. The segregation part is one word.
Mr. Paul, you can have a seat. Why are you standing? Why do you have a...
My back requires me to stand longer than sitting. That's why I was standing. That's what I was advised, so I avoid sitting for too long. Sorry.
No.
That's the reason I stand better.
So far
Do
as
some mobilization exercises for the back. That's a professional hazard for judges and lawyers.
Yes.
So long as you keep your back mobilized, the lower back mobilized, by doing some stretches, that is very crucial.
Advice so
Just 10 to 15 minutes, but we all tend to neglect ourselves,
This can be debilitating.
Oh, it is completely.
And with some people, Lord, we have to sit for some time and stand for some time, and I was standing too.
Even for conferences, that desk now helps a lot, my lords. Stand and do conferences.
Yes.
That's very helpful.
So you do that, is it?
I do that. I've started doing it. So it helps not sitting through the conferences myself.
It's better that lawyers start doing this from an early age, rather than wait for us like to reach our age, and then it becomes difficult to resolve. So there are two aspects.
Yes.
As I said, the segregation aspect, whether the candidates who have been found to be tainted, or rather the tainted and untainted, can they be separated? Is there enough material on record to segregate them? And whether the defects found are so widespread that the whole must go, the whole selection process. That is one part. The second part, with which the state is concerned, because under the Act and the rules, there is a central commission which makes the selection, and there are boards, regional boards, which the board of secondary school, the board of higher secondary school, the board of madrasas, so who make appointments. The state's statutory duty is limited to creation and sanction of posts and bearing the burden of salaries. So they do not come directly into the process of selection or appointments. Now, that is not to say, Lord, that the states overall are not responsible for the education in the state, but the various selection processes which are held from time to time are in the domain of the Central Commission and the boards. So I'm, my lord, confining my submission on behalf of the state to clause 8, which your lordships had stayed, my lord, for the time period. I'm not concerned with the segregation part. The commission's council and the other learned councils who are representing the candidates who are affected, they will be assisting your lordships on the question whether segregation is possible or not. They have the material to show. I'm only confining to clause 8 direction which has been issued and stayed by lordships.
Yes.
Incidentally, my lords, on 23rd of November 2022, Justice Gangopadhyay had for the first time by an interim order, interlocutory order, directed CBI inquiry into the question of creation of supernumerary posts. That order is at page 506, at page 515. And in an SLP filed by the state, my lord, the Chief Justice was pleased to grant an interim order stating that, which is still pending, that is on 25th of November 2022, which is at page 518.
Yes.
That matter is still before the lordships. And one of the reasons, Lord, for this intervention by this court was that none of the writ petitions involved any challenge to the order of the state government creating supernumerary posts. That was never in challenge. The lordship turns to page 518 of volume 2.
Yes.
And the matter came up before Justice Gangopadhyay on account of the fact that the Selection Commission had moved a IA, which they call CAN 2 of 2022 in this matter, where they sought permission from the court for creation of this supernumerary posts. But it appears that inadvertently or whatever it be the motives, I do not want to go into that, but they mentioned to accommodate illegal appointments. The idea was that when the appointments are set aside by the court on account of these corruptions, etc., and there's long drawn litigation which is going on in that court and this court, so in the meantime, some supernumerary posts may be created so that those who are in the wait list, they could, regarding whom there is no issue as yet, so they could be accommodated. For example, in one case, this lady Soma, she had approached the High Court and the High Court itself directed. Her case was that some people who are lower down and not in the list have been appointed.
That is a medical case. I think
medical case, so therefore that was appointed. Now, if you kindly see page 519, item 6.
Yes.
Lordships have extracted the order of the learned single judge in the High Court. It is thus submitted that if any other illegality concerning the appointment of Group D staff is identified, it is humbly proposed that apart from giving recommendations and appointment to genuine candidates as observed by this Honorable Court by its order dated so-and-so, supernumerary posts be also created to accommodate those whose appointments are subsequently found to be invalid, such proposal will result in no loss of jobs and enable such appointees to have means of livelihood. However, in the event of such proposal being accepted, appropriate directions be given that such persons do not have seniority over those eligible for appointment. So while this direction was being passed, the state in fact appeared and told the court that this is contrary to the state's order creating the post, because that was meant for waiting list, not for invalid appointments. That those who are declared illegal, they will again come back through supernumerary posts. That was not the intent, and we produced that order. But even after production, nobody challenged that order. Even that's what I'm showing his purpose is. Nobody even then amended the petition to challenge that order at all. And the lordships have then wrote at page 509, paragraph 4, state this. In paragraph 9, page 520.
Yes.
So this petition is pending. So the question is identical whether the... Yes. So neither it was an issue, nor it was made an issue after production of the order, and it remained as such because my lords had stayed it. Now, the other thing is that with respect to these 6,000 to 861 posts which was created,
6,000?
861. Kindly turn to page 367 of volume 1. The proposals had come from the commission and the board to the state government saying that they have themselves detected a lot of cases of rank jumping and all that.
Yes.
So they themselves detected. So since they had detected, they recommended that from the wait list, that was their recommendation, which was accepted. And kindly see at page 367, having recorded the proposals at the bottom of the page 367. Now, therefore, in exercise of power conferred under Section 19 of the West Bengal School Service Commission Act 1997, the governor has been pleased to create 6861 supernumerary posts of teachers and non-teaching staffs as detailed at para so-and-so for absorbing the wait-listed candidates in the supernumerary posts so created as per approval of the state cabinet. And please turn overleaf. In exercise of the powers under Section 3(2) of the West Bengal Board of Secondary Education Appointment, Confirmation, Conduct and Discipline of Teachers and Non-Teaching Staff Rules 2018, the Governor is further pleased to direct that appointment letters to such waitlisted candidates should be issued in terms of recommendation of the West Bengal School Service Commission in strict compliance of the extant rules, subject to the outcome of pending litigations before the High Court of Calcutta. So there was no attempt to overreach the court.
Can we just go back to that order for a second?
Yes.
That's the page, Annexure 7, right? Page 367.
Yes.
Right. I was just trying to locate it up now.
I'm so sorry. At the bottom of the page I was getting that. So I think PDF is different also.
398.
398. I'm so sorry. At the bottom of the page is now therefore in exercise of powers conferred under Section 19 of the West Bengal Service Commission Act, the Governor has been pleased to create 6861 supernumerary posts of teachers and non-teaching staff as detailed at para 4 for absorbing the waitlisted candidates in the supernumerary posts so created as per approval of the state cabinet.
Yes.
And the next page was 399, that's PDF 399. In exercise of powers under Section 3(2) of the West Bengal Board of Secondary Education Rules 2018, Governor is further pleased to direct that appointment letters to such waitlisted candidates should be issued in terms of recommendation of the West Bengal School Service Commission in strict compliance of the extent rules subject to the outcome pending litigations before the Honorable High Court at Calcutta. So this was all subject to the High Court that if they are set aside, in that event they are to be accommodated. That was the spirit with which this order was issued, and keeping in mind the spirit, not barring Soma, nobody else was appointed at all. The posts remained vacant.
What was the occasion to accommodate 6,800 waitlisted candidates?
The objection really will be now this, that if the, at present, there's no question of appointment because once the whole selection process has been found to be
No,
vicious.
but why did the government create, what is the need
That
for
was
the government
during
to
the
accommodate?
process. During the process, when the selection list had, this judgment had not been delivered, in between the process, there were various inquiries being done, one by Justice Bag's committee, then by CBI, report, affidavits were filed. Commission itself was required to go into it, and they also filed affidavits showing how many rank jumpings, etc.
This selection related to which year?
The same selection was. That's 2016.
Right, and the government created posts in 2022.
They were creating because what happened in this case that all selection list was finalized in 2018. Then January 2019, all appointments had been done. Now this challenge itself was raised in the year 2021, that's after 2.5 years. So that's why in the process, because the records which are to be preserved for 1 year, they were weeded out. All this happened because after 2.5 years, therefore all this problem was arising. So, of course, the problem was of our own making, Lord, so we are not saying.
Suppose a candidate on a select list or the waiting list were to file a writ under 226, give me an appointment. The simple answer would be to such a petition that, well, what is your vested right? After 6 years, you can't even get appointed.
Yes.
Because the tenure of a wait list can never be that long.
Yes.
Now, this was 2016
No,
selection.
in fact, in
In
2019.
22, the government creates 6,800 supernumerary posts.
So, in fact, 2019, it was already declared that this panel is dead. Now, because the writs are being filed in 2021, 2022.
I only added one thing, because the reports came that there are potential irregularities and the matter was pending in the High Court, the fear was that tomorrow if they are struck down, there will be a huge vacuum. It was in that background that a suggestion was made and a whole cabinet note after discussion was prepared that in case that were to happen, where would we go without 25 or whatever 10,000 who are struck down? So why not in the meantime take the waitlisted candidates against whom there is no allegation at all on a supernumerary post subject to outcome of the writ petitions which are pending. This was the suggestion.
Sure, sir.
petition where this order has been challenged separately. Petition. So now the order passed by the state government, which is at page 367. This, as I said, this was never implemented, and ultimately, Lord, in November, a different writ petition, which is WPA number 250-56 of 22, Meenakshi Ghosh, on 18th of November 22, WPA number 25056 of 22. That was filed directly challenging the order of the state government creating these posts, and the High Court was pleased to stay that order. That petition is still pending in the High Court. So the purport of my respectful submission is this, my lord, that it is one thing to say that these orders are illegal. Maybe because panel has expired long back, or the power doesn't exist, or that it was unnecessary. So therefore the order is illegal and deserves to be set aside. And this part of the legality part is engaging the attention of the High Court in the writ petition which I just now pointed out.
250 of 2020.
Yes. 250-56, 25056. So the legality of that, and we are today, given this nature of the order, the question of legality doesn't really arise. It goes, if the selection goes entirely, that goes also. The wait list also goes, everything goes.
But that, Mr. Dwivedi, actually goes against you, because if the entire if the selection itself was under a challenge, then where was the occasion for the government to use the wait list in that same selection process then for creating supernumerary posts? It's aware of the fact that the selection is challenged.
It's like this.
Why would you create supernumerary posts?
Now, can you look at it this way, it was not expected at that stage that the entire selection will go. The way the proceedings were going, in between, there were some orders passed that 329 posts are appointees, they were invalidated. Then 800 were invalidated. So it was expected that some part of the tainted candidates will go, and therefore, Lord, there will be need to appoint from the wait list. That was according to the CBI affidavit, also 8,000.
Of how many candidates?
About 24,000 something. All I am trying to endeavor is to show that there is no malice behind, my lords. Malice in fact. Our expectations, on hindsight, one may say, or hindsight also say that one should have awaited, my lord, the final judgment of the division bench and then proceeded to do something. What I am today questioning is the direction for a CBI inquiry. I am not on the legality part.
That's the point, basically.
Basically, I am saying that not CBI inquiry can be directed only if even prima facie the High Court finds that there is some criminality. So we may have gone completely wrong. It may be illegal. But the fact that we did not appoint and the order said that it is subject to the orders of the High Court. And even the application of the commission said, my lord, we are seeking approval of the High Court. High Court could have rejected that application, the matter would have ended. Assuming the High Court feels that the two are interconnected. Though we said that commission's application is contrary to our order, but yet, for the sake of contention, if I assume that the High Court said it is Binami application is somebody behalf of the government which is wanting to create, but we went to the court, the commission went to the court with an application permit. So court did not permit, the matter ended. It's not that we were trying to overreach and bring into the stream some people from the wait list.
On your application before the High Court
rejected, never passed any order. It's state that they started investigating, and that order has been stayed by your lordships. Justice Gangopadhyay's order, he said that it seems that this is not from the chairman of the commission, there is some higher persons. So, I mean, I don't want to go into that.
So you sought the approval of the High Court. High Court didn't grant that approval, and therefore no appointments were made at all.
That was an application by the Selection Commission.
Selection Commission.
Which traveled to the Supreme Court, and your lordships passed the stay order. Ours was an independent exercise as far as supernumerary posts are concerned, because these were from the waitlisted category.
Okay.
But so I'm going a step ahead and saying, Lord, even if the
is there a finding of criminality by the High Court while referring?
Nothing. Can you see that there's no discussion at all?
All right, that's the point.
That's my humble submission, and I rely upon this judgment of full Constitution Bench judgment of this court, 2010, Volume 3 SEC.
Yes. Page
571.
Name.
State of West Bengal versus Committee for Protection of Democratic Rights.
Well settled.
Para 70 and 71. The last two paragraphs. I'll just read out. Lordship may not.
That you shouldn't pass it as an order.
And that Para 71, Your Lordships approved minor irrigation case 2002-5 SCC 521. This court had said that an order directing an inquiry by CBI should be passed only when the High Court, after considering the material on record, comes to a conclusion that such material does not disclose a prima facie case calling for an investigation by CBI or any other similar agency. We respectfully concur with these observations. And in this case, Lord, with respect, Lord, there is absolutely no finding, Lord, the prima facie of any criminality, nor can there be. First of all, Lord, there is no issue. Even when we produce the order in the Can 2 of commission, still thereafter nobody amended the petition. Nobody is saying, Lord, that this order has been passed with a malice. Secondly, in both the cases, our order also says, Lord, subject to the orders of court and the application itself of the commission, though little misconceived and erroneous, still it said ask for permission. So there was no case, that somebody is trying to bypass the whole judicial process, and investigations going on and appoint from the wait list. And thirdly, nobody in fact was appointed. So in fact, there could not have been any finding of criminality, nor there is.
Mr. Dwivedi, the CBI investigation had been directed to continue by our court itself.
That's right.
So there was a CBI investigation going on in regard to the criminality in the main
in the main matter about those appointed.
Which would also include the waitlisted candidates.
Yes.
Now, if that was so, then is the High Court not really only in this direction of the High Court? Is it not in furtherance of what we have directed ourselves?
No, your Lordship directed in continuance of CBI inquiry, which was already going on with respect to those who have been appointed, namely rank jumping, namely outside the sanction post, more than the sanction post, they were being appointed. Those who were where this OMR sheets problem. So they were investigating the selection process.
Same selection process, right?
But we have nothing has been appointed. Nothing has happened. Where is the question of criminality if the government passes an order which remains on paper? So what can be an attempt to commit what crime, my lords?
All right, we'll
so that's the issue, my lord, which I am raising. And moreover, my lord, lordships have said apart from this judgment that there has to be compliance with natural justice. No pleading, no issues. Where is the hearing going on this aspect? Focusing on this aspect. Then the state should have been put this issue directly, not whether why should not that CBI inquiry be directed? Then all these arguments, Lord, we would have placed before the High Court. The High Court would have considered these questions, these aspects.
Thank you, Mr.
May I just add two submissions for your Lordship's kind
Yes.
consideration? Admittedly, it is a fact that a single judge of the Honorable High Court was seized of the cabinet note issue. This matter was neither argued, nor were we ever called upon before the DP, nor was the subject matter of the matter pending before the division bench, the cabinet note at all. But more importantly, please see, where does the impugned order go completely wrong? Kindly have page para 265 on page 226 of the impugned order.
Para?
265.
What page would that be? Do you have a
Page 226 of the paper.
257.
PDF 257.
Yes,
My lord has that.
yes.
The state government, therefore, has accepted that there were widespread illegalities in the selection process and that the number of persons who received appointments illegally could not be determined with exactitude. They had resolved to create supernumerary posts to accommodate illegal appointees. In other words, state has reserved to expend taxpayers' money to accord sanction to an employed secured dishonesty. There is no appointee as far as the waitlisted candidate is concerned. They completely mix it up with the earlier recommendation which were not just stayed of the SSC. This was a cabinet note prepared on waitlisted candidates. No one had been appointed. So there were no illegal appointees. Now read this, my lords, with para 355. Please read this with para 355 on page 277. PDF 308, my lords.
The issue of whether the reference should be made, this investigation should be made by the CBI or not.
I am instructed to say, subject to correction, I am instructed to say this was never an issue before the division bench, never argued, never called upon to answer. It is pending before another judge. It's pending before the single judge in Calcutta High Court. Let's kindly have para 355 of the impugned order, page 277, and PDF 308.
Suggesting what would you want to us to see, Mr. Kaul?
Para 355 on page 277, PDF 308. What's happened?
Yes.
Investigation by CBI with regard to the creation of supernumerary posts is imperative to bring to light the nature and extent of the scam and persons that are involved therein. It is shocking that at the level of the cabinet of the state government, decision is taken to protect employment obtained fraudulently in a selection process conducted by the SSC for state-funded schools, knowing fully well that such appointments are obtained beyond panel and after expiry of the panel at the bare minimum. So the state cabinet, all departments, the entire memorandum which is prepared under the state rules. And I'll just show to you, Lordship, there's a whole rule, there's a whole procedure, rules of business. The manual concerned of the state government under which cabinet notes are prepared, the administrative department, legal department, finance department are all consulted. And then a cabinet note goes up to the cabinet. So you are today saying, firstly, you get it wrong, you talk about illegal appointees. These are waitlisted candidates. Secondly, you today want to include criminality. And look at the dangerous precedent it sets that in every matter of these kinds, the entire cabinet, the whole process, everyone will be subjected to a CBI investigation. And most importantly, now see, my lords, in this background, paragraph 363, subclause 8, what is the direction given? The direction given is on page 363 at page 281, clause 8.
Yes.
CBI will undertake further investigations with regard to persons involved in the state government approving creation of supernumerary posts to accommodate illegal appointees. If necessary, CBI will undertake custodial interrogation of such persons involved. So, my lords, today, as your lordships are well aware, with the entire West Bengal Secretariat Manual, Chapter 6, rules of business, officers involved, departments involved, everyone who prepared this, including the state cabinet, the advocate general, everyone will be subjected to, because the legal department, the finance department, everyone is involved. The approval of the legal department was taken. Everyone will be investigated by the CBI and if required will be taken into custody. And please see 118, what were the issues framed by this court in this matter, my lord? Because your lordship asked me a pertinent question. Was it my instructions were never argued, never raised, not the subject matter. But the issues are called out in para 118, PDF 191, para 118.
Yes.
The premium numerated rival
We've seen that,
contentions have been
we've seen that.
delineated the following issues for consideration. Does this division bench have jurisdiction to hear all the writ petitions and appeals listed before it? Are the writ petitions maintainable at the behest of unsuccessful candidates who has filed writ petitions subsequent to the expiry of the validity period of the panel? Can appointments be made subsequent to the expiry of the validity period of the panel? Is the certificate dated so-and-so valid and admissible in evidence? Should the OMR sheets available in the seized hard disk be uploaded in the server of SSC to compare with final list stored therein? Should any reliance be placed upon the data stored in the seized hard disk to terminate the services of any employee? Can the recommendation be withdrawn by SSC without hearing the appointee? Whether revocation of recommendations under Rule 17 by SSC is valid or not? To what relief or reliefs are the parties to the appeals and repetitions entitled to? Well, with respect, apart from not being an issue, it's an extremely dangerous precedent that we are setting. What are we saying? That a court without an issue being raised, discussed, today orders a CBI inquiry if required with custodial interrogation, right going till the cabinet, with no proof, nothing, no suggestion of any criminality, and everyone gets roped in. Now, the whole cabinet process of decision making, my lords, in a parliamentary democracy, where do we go? Look at the far-reaching consequences of this direction which is being given. Apart from getting it completely wrong at the cost of reputation, talking about illegal appointees rather than the waitlisted candidates, where the cabinet note says there may be potential irregularities. Tomorrow, let there be no vacuum. Let people be taken from the waitlisted, subject to outcome, subject to court. The SSC recommendation, where they took permission of the court and where they wanted to apparently withdraw it, ultimately they refused them to withdraw and ordered a CBI inquiry. That also your lordship state. But this is much graver.
Yes.
So, my lords, our respectful submission is that A, there was no occasion, no issue, no argument. But even on a principle of law, my lords, can such a far-reaching direction in the manner it has been given, be really be sustained, apart from the fact that here no one argued this point?
Right.
I'm extremely grateful, my lords, for your lordship's kind consideration.
Who would be answering this petition?
My lords, our only other issue
Mr. Gupta,
was...
you are also on the same side?
Yes, Lord, I am for the commission.
My lords, our only other consideration will also be this, we lordships may keep in mind, that today it's not even CBI's case that 25,000 illegal appointments have been made. In one rush to cancel everything, my lords, creates and leaves the state with a situation where there's a huge vacuum, the teacher-child ratio, various other requirements under the Act, everything today goes for a 6, because suddenly en masse, you say that 25,000...
That's on the second issue, whether segregation is possible.
Yes, that's a segregation.
Surely?
Yes. Yes. That is the other point
Okay.
which we are extremely concerned about. Very grateful.
Yes, Mr. Gupta?
Yes, my lord. Just 2-3 facts, my lord. First of all, my lord, the advertisements are given out, my lord, in 2016 for this batch of recruitment. There are 4 batches, my lord, 4 categories of persons to be appointed. First one, my lord, is class 9 and 10 teachers, assistant teachers of class 9 and 10, for which there is a rule of 2016. Secondly, my lord, teachers of 11 and 12, for which also there is a separate rule of 2016, similar rules. Thirdly, my lord, Group C and Group D employees, clerical and, my lord, subordinate. Most of the appointments, my lord, were completed in 2018.
Which is the fourth category?
Fourth category is, my lord, C. Third category is C. Fourth category is D. Group C, Group D. Clerical and subordinates. Non-teaching, yes. My learned friend is right, my lord. The third and fourth categories are non-teaching.
Yes.
Now, my lord, the appointments were given on various dates after counseling. My lord, mostly in 2018. And my lord, they started working from 2018. In 21-22, my lord, the writ petitions started coming in. By this time, the panels, validity of the panels had gone.
How long was the validity?
My lord, different dates, my lord, but 1 year with my lord, 6 months extension possible in certain cases, and my lord, in some there is no date, my lord. There is no, my lord, period mentioned. Now, in 21-22, my lord, these matters were brought in, my lord. There was a series of orders by the learned single judge, some of which came to this honorable court, my lord. And one of those matters, my lord, one batch, by an order of 9th of November 2023, was, my lord, remanded, but not to the judge, but, my lord, to a division bench. Now, this did not cover, my lord, the whole batch of matters which were before the High Court. It covered some. This went to the division bench. The division bench has taken this, my lord, stand. This is the judgment which is before your lordship today. Now, my lord, this is the first appeal. The learned single judge did not dispose of the matters. Before that, your lordship said he will not dispose of these matters. It will be disposed of by a division bench. So, my lord, the division bench disposes of this matter for the first time. And this, my lord, is the first appeal we have. Now, what is the substance, my lord, of this order? Your lordship has seen, my lord. First of all, the issues, if your lordship sees, and then I'll go to the directions. The issues are at paragraph 118, page 187 PDF. And my lord, on the side, I'll put the answer also, my lord. Now, just see, my lord. Does this division bench have jurisdiction to hear all the writ petitions and appeals listed before you? This was because this hearing was set up pursuant to a particular order of this honorable court, which dealt, my lord, mostly with the OMR sheet problems. And, my lord, the learned Chief Justice was directed by your lordships to place it before a bench. Now, the learned Chief Justice, my lord, passed an administrative order, and, my lord, it was placed before this division bench. The first contention was that this means that a particular batch is before this court, not everything.
The entirety.
Right.
Yes.
Well, I'm not making too much of an issue with regard to that, because the court said, let us treat it as a PIL. But, my lord, the result is, my lord, that there are many matters still pending before the single judge on this very batch. There are many matters pending before the appellate court, and there are several matters pending in this honorable court. And now, my lord, there is an actual conflict between orders of this honorable court and this judge. My lord, I am only pointing out, my lord, that it is not possible, my lord, for this matter not to be heard out. Notice, my lord, and your lordship must hear it out, my lord. That's, my lord, where I am going now. Now, then, my lord, that was the first one. Answer is yes. your lordship sees at 118, whether they have the jurisdiction, answer is yes. I'm just saying, my lord, the judgment says. Second one is, are the writ petitions maintainable at the behest of unsuccessful candidates who have filed the writ petition subsequent to the expiry of the validity period of the panel? Answer is yes, primarily on the basis that we are taking it up as a constitutional court. It's a public interest litigation. So the maintainability will not come in the way. Then, my lord, can appointments be made subsequent to the expiry of the validity period of the panel? Now, my lord, this is not investigated at all. In one particular line, my lord, it is just said casually that it can't. Now, my lord, there is a factual background to it. Sometimes there is a rule backing it. Sometimes there is an executive order backing it. And there is a reason for, my lord, the extension. Because, my lord, for various reasons, my lord, the actual counseling had got delayed. And, my lord, there was COVID also. So, therefore, that is no. The answer is no. 4, my lord, is the certificate dated 19th of September 2022 valid and admissible in evidence? Answer is yes. And I'll give you a lordship.
Mr. Gupta, you are paying for the commission, right? You didn't
Yes.
create these supernumerary posts. It's really the state of wisdom.
Supernumerary post is one small aspect of this matter, my lord. Very important, no doubt. The state is concerned with that, my lord. But the real substance of this matter, my lord, is the cancellation of the my lord appointments. I will come to, my lord, the directions now to show your lordship, my lord, that this kind of a far-reaching order, which affects, my lord, a huge number of people, which is blatantly unfair on the face of it, because people who have actually taught for 6 years are being told that they have to give back the money that they have been paid as remuneration.
So you're now arguing the broader aspects of the matter.
No. These are directions. I'm asking for stay. I'm asking for notice and stay, not broader aspects.
Now, when did you destroy the OMR sheets? Is there any specific provision as to how long the
There
OMR
is
sheets are?
specific provision. There is specific provision. We are supposed, Rule 21 is there. We are supposed to, my lord, ensure that digital copies are maintained. Digital copies were maintained. Of course, my lord, it has been recovered from, my lord, an employee or an ex-employee of the concern which was asked to scan it. Now, regarding that comes, my lord, the fourth, my lord, question or issue. That gentleman has given it to the CBI that, with a certificate. My lord, the court said there should be a certificate under 65B of the Evidence Act. So,
But you gave the scanning work
yes,
to that NISA,
yes, correct.
right? Now,
Yes.
NISA appoints that data scan tech.
My lord, yes.
Your
We don't
chairperson,
know that, my lord.
your chairperson says, I'm not even aware of the appointment of data
That's
scan
correct, my
tech.
lord, but this is not an outsourcing. NISA retains full control, my lord, who they are sending to my office to scan it actually, whether it is an employee of NISA or whether he is using some other person to
And
do
you
it.
appoint NISA without even a tender.
No, my
You
lord.
just sort of award the contract to NISA.
All this, my lord, is the kind of, my lord, overriding statements which are there in the judgment. NISA was appointed by way of a limited tender, in the sense, my lord, that several organizations were asked to quote, and this was found to be the best quote. 4 organizations were asked to quote. Your lordships have said as early as 1986 in Sachidanand Pandey that it is a valid method by which the government may, my lord, farm out work. There can be a limited tender. It's a very specialized job. It did not require a global tender, my lord, according to us. And, my lord, the whole thing is, my lord, that they have come, they took the contract. Who actually went into the office and scanned it, my lord, was their concern. We have no relationship with data scan. Now, so therefore, my lord, ultimately.
Now, the OMR sheets have been destroyed. You say that because under Rule 21, they had to be destroyed.
That's right.
But even the mirror images on the scanned sheets are not in the SSC
That's
server.
right, my lord. It was, my lord, being accessed from NICE, NYC. It was being accessed because, my lord, people would come with queries. After the date of destruction of OMR sheets, when people came with queries, we took the data from that organization and gave it to them. Now, my lord, just for a moment, my lord, my stand on this OMR sheets digital data is, my lord, that we have proceeded on that basis. When the CBI obtained the digital data and my lord, the court said you should back it up with a certificate under 65B. The commission thereafter proceeded on that digital data. So, my lord, it is true that there are many parties before your lordship who are arguing that 65B has not been satisfied. So, therefore, this digital data is not to be looked into. But, my lord, the consequence of not looking into it is that then there will be no evidence to show that there is a discrepancy between OMR and the, my lord, what is on the final marks in our server. But we are not saying that. We are saying we have accepted those and we have looked into it, and based on that, my lord, the segregation is to be done. So, my lord, 65B, my lord, is something which will be argued by other persons. The commission, my lord, has so far actually said, all right, very well, we will go by what the CBI has given us. So that is, my lord, issue number 4. My lord, may I show, my lord, the 5th issue? Should the OMR sheets available in the seized hard disks be uploaded in the server of SSC to compare with the final list stored therein? Answer given by court is yes. And, my lord, apart from, my lord, the question as to whether this should be made available to the public in general, 22 lakhs, my lord, or whoever is interested, we have no grievance with, my lord, uploading it and comparing it.
But now, Mr. Gupta, if
Yes.
you go back to now para 335 at PDF 298,
Yes, ma'am.
where the court sums up what it has found.
Yes.
Let's just read para 335 at page 298. This is
Yes.
your card. The evidence placed before us have established the following illegalities in the selection process.
Right, my lord.
Now,
335.
Yeah, just read.
I am going to place this, my lord. The evidence placed before us has established the following illegalities in the selection process. SSC has appointed an agency, NISA, for the purpose of scanning and evaluating OMR sheets by a closed-door tender process in violation of 14 and 16 of the Constitution of India. Answer is no, because Article 14 and 16, your lordships have said, allows limited tender process. The judgment, my lord, and there are several.
How many bidders were there?
My lord, there were 4 bidders.
So why did you not issue a proper tender? You're dealing with something as sensitive as the appointments to the SSC.
My lord, your lordship may,
Appointments to the,
Lord, your lordship may come to that conclusion. I'm not saying. Today we are arguing for notice. It has not been considered. The court says closed door. There is, my lord, a legal concept which is missing in this analysis, and that is of a limited tender. A limited tender, my lord, in...
Let's first read
Yes,
this whole para.
right. I'm just answering as I go along, my lord, if your lordships will permit. Otherwise, I'll read first and then...
That's okay.
Yes. Number 2 is, my lord, such agency has engaged another agency, namely data scan to scan. Now, this is not illegal, and we are not aware. They are getting their job done. They have not...
Surely the Staff Selection Commission must introduce a condition that you will not hand over this to somebody else.
No, my lord.
Because these are matters of confidence, of trust.
Most certainly it is a
You have
matter of confidence.
you have to say that, look, you will do it yourself, otherwise don't bid for the project.
My lord,
The fact that you did not prevent outsourcing shows that you had just turned a blind eye to
No,
the whole
no, I'm not-
sanctity of the
my lord,
process.
my lord, no, this is not a case of somebody coming and saying, I'm introducing a new person. This is, my lord, nice, doing its job. And I am not, my lord, aware that there is another organization which has got involved in it. This didn't come to our attention till the matter was going on. So
Alright,
therefore, my lord, as far as we are concerned, my lord, nice executives were in our office doing the scanning. My lord,
Now just think, we'll continue 3, 4 and 5. We'll just...
Right now 3. Although scanning was done at the office premises of SSC, it is claimed that SSC has never engaged data scan tech. Naturally, my lord, we are saying the data scanning was done by NICE. Now, NICE says that the actual operatives
But when data scan takes employees enter your office, surely you know that somebody else is entering my office to do the
not
scan.
disclosed, my lord, not disclosed.
But if your staff is there, your staff is supervisory. For instance, we have scanning agencies in the Supreme Court.
Yes, ma'am.
That scanning agencies, people come here for the purpose of scanning. If they induct somebody else, it's our responsibility to know if there's a third party which is entering into our premises.
Yes.
Because our supervisory control, our officers are doing the supervisory control over who is the authorized agency who is entitled to do the.
My lord, I'm
who's
very
duty
sorry, my
bound.
lord.
Somebody-
No
they-
third
they
party is
start
entering.
enforcing.
My
Our
lord,
staff cannot say, well, I don't know who else came in
My
because
lord,
you have.
I know who came in. They came in as nice employees. There is no indication that the person concerned was somebody else and not nice. That's not meant to be, my lord, a pun. Now, my lord, so my lord, data scan, my lord, in my respectful submission is a red herring because the work is given to
Now
nice.
see what follows.
Yes,
Four.
right. My lord. Four.
SSC
Four, SSC has destroyed the original OMR sheet ostensibly with scanned mirror image thereof being preserved in its server. Now, my lord, destroyed in accordance with rules, my lord, we say,
All right.
your lordship may consider that. That's all. CBI did not find any scanned mirror image in the server of SSC. That is true. Because, my lord, we relied on, my lord, the person and the NICE gave us the data at all times. Even today, my lord, NICE is giving the data. Whether, yes. Whether, my lord, it is from an ex-employee, whether it is covered by a 65B certificate, all those are questions. But, my lord, the data which the CBI is using, which I am using, all that data has actually come from NICE. Now, my lord, C6, OMR sheets have been destroyed without scan. So, my lord, therefore, there is
So
no...
now when you destroyed the OMR sheets,
Yes.
it was the Staff Selection Commission's duty to ensure that the mirror images are preserved in the server.
So, my lord, if the...
Now there is no mirror image in the server at all.
So, my lord,
Because your case is that, look, I was duty bound to destroy it after a certain stipulated period.
Lordship.
But equally, it is your responsibility as the SSC to keep the images, the scanned images in the server.
my lord, fair enough, my lord. The question that your
Why have they
lord...
not been preserved in the server?
But, my lord, it is being preserved
Where?
in NICE.
No, but CBI doesn't find it in
No.
your server.
No. The digital information is to be preserved.
But in your server.
Now, it has not been found in my server, but it is found, my lord, where it was taken.
But it's worse because NICE at the highest is only an outsourcing agency. Imagine your entire data is now found in the server of an outsourcing agency.
So now, my lord, would
Can
your lordship...
can there be a greater breach of security protocols?
My lord, would this be enough, my lord, to set aside, my lord, the employment of 25,000 people is the question. Now, these three paragraphs, my lord, are actually one point itself. One point.
Then of the whole process.
So if CBI is proceeding on that basis, CBI is taking that data only to prosecute.
Now, if these were destroyed,
Yes.
look at 7.
Yes,
SSC had provided scanned OMR sheets to RTI applicants in the year 2018 till 2020.
NICE, my lord, from NICE. From NICE.
So that means you knew that the entire data was maintained with NICE.
Of course I did. Not data scan. It was not maintained with data scan. It was maintained with NICE.
What was maintained with NICE?
The data, the entire data, digital OMR data.
But how can that means that you are the statutory body? You allow the entire scanned data to be maintained by an outsourcing agency. It's only a labor provider to do the scanning.
But today, my lord, today that very data is being used in a prosecution. So, my lord,
but today we are looking at your breach of your statutory.
My lord, your lordship may look at my breach.
Yeah.
I am only going to show your lordship, my lord, what is the
Now
actual...
you can't say that, look, NICE took it away.
My lord,
You are responsible for maintaining it. It is people's data. It is people's data.
please don't misunderstand. I am not, my lord, blaming NICE. I am not blaming NICE. I am even accepting, my lord, that without a 65B or not.
Now see what follows.
My lord,
Appointments higher than the declared.
My lord, if I may just add one thing here, my lord. My lord, if I may just add one thing, my lord. This very data.
In 7, they say,
I'm not running away from a single clause. Just let me finish this submission, my lord.
Yeah.
That the very data that is being used by this court in this judgment and the data which will be used in the prosecution by CBI has completed its investigation. It has said so to the court that we have completed the investigation. Charge sheets have been filed. Now, my lord, that is going on. Now, question is, my lord, this very data is going to be looked at for both the purpose of this judgment and that. So, my lord, the authenticity of this data is not going to be under challenge.
Now see 7.
Yes, my lord. Now 7. SSC has provided scanned OMR sheet to RTI applicants claiming that such was from the database, although CBI did not find.
So
My lord, we are
you
saying
have,
that.
you have responded to RTI queries
Yes.
saying this is from my database.
No, I don't know whether it said mine.
Yes.
Just said database.
No, from your database. And now it's come to light that this is not in your database at all. That means what you were saying to RTI applicants that, look, this is in my database.
So,
That is incorrect. Look at the Staff Selections Commission's modalities of conducting it, Mr.
my lord, it may be, my lord. It may be, but that same very data is being relied upon. Today, this judgment would go if you take away that data. It will have to be set aside. Because, my lord, in one chapter,
There is no data at all.
suppose there isn't, my lord. Suppose there isn't. Then what will happen to this judgment?
But then the appointments have to go.
My lord,
Because either you have the data.
yes.
If you don't have any data, we understand that OMR sheets in the physical form, you can't maintain
Yes.
them in eternity.
Yes.
But then two things. You are duty bound to maintain the underlying documents in a digitized form.
Yes.
Because now today with digitization, it obviates the requirement of all that storage and everything.
True.
Now you say that, look, I don't even have the, you provide RTI responses saying this is from my database. Now it's obvious that there is no data in your database.
All right, my lord.
That,
My lord, all I'm saying is, my lord, that
NICE
I am
is the
saying.
only agency.
All right.
NICE appoints data fintech.
No, my lord.
You are unaware of the fact that your service provider has further subcontracted the service to somebody else.
My lord,
Surely
your
you have to
lordship
keep,
may hold us.
you have to keep supervisory
My lord,
control.
Very well, my lord. I am not, my lord, on that. I am saying that the very same data which your lordships, my lord, are doubting is the basis for the CBI prosecution and this judgment. So if your lordships, my lord, are not to look into that data, my lord, then this whole judgment has to change. It may still lead to, my lord, investigation, but it cannot be, my lord, what is happening now.
Now, appointments
Yes, my lord,
higher
next.
than the declared vacancies have been given in respect of all 4 categories.
Appointments higher than the declared vacancy have been given in respect of all 4 categories.
Appointments given to persons who are not even in the panel.
Yes.
Appointments given to persons who submitted blank OMR sheets.
Yes.
Appointments had been given to persons after expiry of the panel.
Yes, ma'am.
Persons placed lower in rank had been given appointment in preference to persons placed higher in rank in the merit list.
Yes.
Merit list containing marks obtained by respective candidates have never been published.
Yes.
Counseling had been held subsequent to the expiry of the panel.
Yes, ma'am.
Total beneficiaries of the illegalities are yet to be identified and rendered improbable given the stand of SSC board in the state. SSC had applied for permission to create supernumerary posts to accommodate the illegal appointees, and recruitment rules governing the 4 categories had never been adhered to either in letter or...
No, that last one is a conclusion.
That's it.
Now, my lord, I have made a chart. We have exact data as to which category which appointment falls into. And my lord, we are not defending. We are not defending appointments which have jumped the list. We are not defending those appointments which have come outside the panel. We are not. We are saying, my lord, that the 16,000 of this 24,000, 19,000 of this 24,000 are not tarnished by any of these clauses. And it is very easy to demonstrate it. It is very easy to demonstrate. We have prepared the chart. The chart will show, my lord, that out of this 24,000, 19,000 were appointed from existing merit lists in accordance with the merit list, within vacancy, within time, everything. And my lord, we were the ones who came forward and gave that data to the court, saying that these are not certain my lord, appointments cannot be justified.
So according to 19,000 are within the merit list.
At least, my lord, that is our rough, my lord, estimate at this point of time. And we told the court that we are prepared to do this exercise all over again. Please see one paragraph only of the judgment, my lord. My lord, page 99. I think your lordships are looking at another SLP, but I am on, my lord, paragraph 33. My pagination, because I'm in 10.1, may not match, my lord. But look at 33. In fact, my lord, I'm sorry.
Page 124 above.
124 PDF.
finally বুঝতে পারবে
which is recorded in the judgment.
How do you displace these findings, Mr. Gupta?
Milord, I'm not displacing all those 4 categories, Milord. I have segregated now.
But look at, it's a systemic fraud.
Milord, just look at the directions then, Milord.
Systemic
Is this
fraud.
fair? Look at the directions now. Milord.
And ultimately, Mr. Gupta, what happens is this.
Yes, Milord.
Today, public jobs are so scarce
Yes, Milord.
and so valued
Yes,
that if the faith of the community in public employment goes,
yes,
then nothing remains. Because today, public jobs and public employment is extremely valued.
yes,
It's a source of social mobility for people coming in from the lower strata.
yes.
People only aspire that, all right, my daughter and my son will get a government job. If this is the way, I mean, we are virtually purloining public employment. What remains in the system?
But Milord, your lordships have said.
How do you
that-
displace these findings? Mr.
Milord, your lordships have said so in several judgments that if it is possible to segregate, we will not set aside the panel. I'll just show you, lordship, just 2, Milord. One is your own
That's
judgment.
right, where I think Madhu Diwan had appeared.
Yes. And I'll show you, lordship, one other paragraph, Milord, from another judgment of the same year, 2021, which says
But
that even if.
interestingly, that was the case where the entire process was set aside.
Yes, correct.
Not by us.
But here, your lordships have also had occasion to say that even if there is a small possibility that it is possible to segregate, we will explore that possibility. Because on the one hand, what your lordship is saying is right, that people, my lord, have an expectation of public employment. On the other hand, my lord, these very persons will be on the street.
But you have nothing to show that this is the data which I have maintained.
My lord, I'm sorry, my lord, if this
Where do you
data is to
have,
be.
what do you have within your system? Any traceable record to show that this is the data I have maintained?
My lord, the prior chairman of this organization is being prosecuted on the basis of that data. Surely, my lord, if your lordships were to cast doubt on that data, then no criminal prosecution can be based on it. My lord, let us, my lord, proceed on the basis. As far as I am concerned, my learned friends may have some other argument, but let us proceed on the basis that the digital data which the CBI has obtained is going to be relied upon. It is another thing that it has come from the custody of the outsourced person. But it is being relied upon by a law court.
Anything
In
else?
para 30
We'll have to hear the others also.
Yes,
now.
Milord, I'm just give me 2 minutes, Milord. In para 33, we have said that we can do the job again. So, Milord, it is not correct to say that we did not offer to do it again. Para 33 has recorded it. The second point is, Milord, para 240 is the only statistical analysis of page 229 PDF, para 240 of item 10.1.
229.
229, yes, my lord. Paragraph is 240 of the judgment.
1 second, that is the wrong.
No, that is because, my lord, your
What is the
lord probably has 10.
240 PDF. 240 PDF. 240.
Para 240, my lord. Page 229 is in 10.1. 240, yes. Now see, my lord.
Para 239. Para 240.
240 is a chart. My lord, I am showing it, my lord. Why is my learned friend getting agitated? My lord, just see, my lord. Alleged irregularities in percentage, 8.5 for assistant teachers of 9 and 10, 14.7 for 11, 12. The other two are very high. Now, the problem with this order is, my lord, to bunch and put everybody in the same basket. Second proposition, my lord, this is the data taken from, my lord, the CBI record. Now, are we to rely upon it or are we not to rely upon it? That's the question before your lordship. If we can rely upon it, my lord, segregation is possible. If we are not to rely upon it, then, my lord, there is difficulty.
Yeah.
But then, my lord, the judgment doesn't stand. Some other recourse has to be sought, my lord. Even then, my lord, your lordship will have to go into the question. My lord, just 2 more points, my lord, I'll sit down. My lord, No. My lord, very important point, my lord. This segregation has to be done inevitably even under these directions. Just look at direction number 4. Of course, my lord, we are submitting that this is an unfair order. Even if, my lord, everything is correct, it is still unfair to say give back the money which you earned by teaching. But C5, 4. Persons who have been appointed outside the panel after expiry of the panel, as also those who submitted blank OMR sheets but obtained appointments, must return remuneration with interest. With interest. So only 3 categories have to remand it, give it back, refund. So the segregation has to be done. And upon segregation, there will be a large group of people who are not required to give up the fund, the payment. Now they will be faced with a situation that they have lost a job, but they are not held responsible. My lord, two more things, my lord, I'll sit down. Now, my lord, this eighth direction or the seventh direction, eighth direction, your lordship has already stayed. The seventh direction, further investigation by CBI in respect of all the four cases, meaning the four categories. My lord, on 9th of January 2024, a comprehensive report was given by CBI saying that they have completed inquiry, investigation. And final charge sheet has been filed. Now, my lord, by what process, my lord, can the writ court say you reopen that investigation now? My lord, that statement by the CBI, my lord, is contained in 9/1/2024, page 743 PDF of, my lord, item 10.1. I've run out of time.
Yeah.
Last submission. Yesterday, my lord, we have sat and found out various categories. As I told your lordship, my lord, the categories include those who have been recommended as per merit list and some who have been appointed pursuant to orders of court. So these two categories, my lord, should not be, my lord, subjected to, my lord, this cancellation is our submission.
Yes.
Secondly, my lord, as far as extending the period of the merit list, validity of the merit list, my lord, that we wish to defend. Because, my lord, there are, in some cases, there are rules, in other cases, there are executive orders for stated reasons. We wish to defend that beyond the period.
Yes.
We do not wish to defend, and we wish to segregate persons whose OMR data, digital data, does not match our server.
Yes.
We do not wish to defend persons who were appointed from the waiting list, not in accordance with rank. Rank jumping is the phrase, my lord, used here. Summarizing.
Yes.
We do not wish to, my lord, support anybody who is not in the panel and has got appointment.
Yes.
And, my lord, there are some people who have been appointed without our recommendation at all. Those also, my lord, we are not defending.
Yes.
My lord, I'll just give your lordship the judgments. Your lordships are aware. 2021, 4 SCC 631 is your lordship's judgment. 4 SCC page 631, paragraphs 35 and 55.
Yes.
And 2021, 7 SCC 613, 7 SCC 613, paragraph 73.
Yes.
Which says, my lord, that if it is even possible, then one should prefer to segregate rather than cancel the whole. So, my lord, this is my submission.
Yes, Mr. Ranjit.
Something shocking has come, sir.
Lord, may I please be excused, my lord? If your lordship requires, my lord, I'll come back.
Is this seat?
My lords, I appear with Mr. Ghosh for the West Bengal Board, my lords. The Board of Secondary Education.
Yes.
My lords, we are the ultimate beneficiaries of the process because we get staff entirely through the Staff Selection Commission. And whatever they recommend or whoever they recommend, we normally appoint. My lords, today, my lords, in the state of West Bengal, I believe there are about 132,000 teachers. And this judgment affects about 17,000 of them, at least. Almost 18,000, I'm told. So that, my lords, is almost 1/6 because this also is a specific category of teachers from the 9th standard onwards. My lords, there is nothing in this judgment about great irregularities on our part, so there is nothing that I wish to open further. My lord, I would join in the request made by council before me, my lords, that where segregation is possible, in the interest of continuing education, and also in the interest of the state that it should have reasonably trained students, teachers. So
Bear that in mind. We'll bear
yeah,
that.
they have had 6 years of experience. Now, what will happen, my lords? If these people, if we lose a whole chunk or a whole generation in between, we will not have senior headmasters, we will not have senior examiners at a later stage. Right?
I will bear that in mind. The
Please,
general
ma'am.
considerations will bear. Thank you, Mr. Agrawal.
Say, your lordships will also bear in mind the fact that many of these people did not get any notice. Those, only those where there were specific allegations, they came to court, they had notice. But it was not as if there was a general notice.
Thank you, Mr. Agrawal. Yes, Mr.
Just one more request, my lords. And this is what sometimes, my lords, when there is a headache, you don't cut off your entire head. That's the argument.
All right. Yes, Mr. Andrew.
Very conveniently in late.
No.
Lord, our case is slightly sui generis, Lord, if I may use that expression. For this reason, that we were people who were working from 99, 2007, 2011, 2001. What had happened, Lord, just let me explain. There was earlier a zonal system of appointment of assistant teachers. So the zones were such, Lord, the rules were that if you are in one zone, you can't be transferred. So many of these assistant teachers were far away from their homes, not in the big state of West Bengal. So they got an opportunity in 2016 by this advertisement that they could participate in the selection process. Now, by this participation, quite a few of them have been able to get appointment or posting in a place which is near, because now it has become centralized. From 2016, the whole process became centralized for the entire state. So therefore, because the entire state became one, so persons wanted to take a try that if I can be nearer, assistant teachers as they are. So these are persons who sat, they were given no objection to sit for the examination. They sat for the examination, they were found successful, and thereafter they were appointed, they were given continuity of service, their pay was protected, and their service books remained the same. Now we got notice of this, sorry.
How many of?
We are 367 persons.
Who were appointed since?
So we placed a chart at page number 733
Of
17.
in item 17.6. Item 17.6. The chart is at page 733 of all the PDF. 733 is of all the 367 people. One person is due to retire next year, in fact.
17.6.
मेरे पास तो है ही नहीं 17.6.
17.6.
आज का 10 ना?
The name is Atanu Chaudhary.
Annexure P40.
Annexure, it's P42, P42.
First name is
P40, I'm obliged. Sorry, it is P40.
first name is Atanu
Yes,
Chaudhary,
Atanu Chaudhary, Milord.
and the internal page is 733.
766, Milord.
733.
Yes, Milord.
Right.
Wait, that's 7.
Okay.
Yes, Milord. Much obliged. Much obliged. So the first name, if your Lordship just have a look. He was first person was appointed on 11/10/2007 in the 5th column, Milord. Your Lordship will find first date of joining service 11/10/2007 in Purulia. That was the first district as per the zone. Now he has joined again on 26/9/2018 in Hooghly. And his permanent address, if your Lordship see the 4th column, was Milord in Chandan Nagar, Hooghly. So they were given permission to participate. They left their lien and the old job, and they have forgone that job. They have joined here, and they have been working since then for the last 6 years. Milord. If your Lordships were to see, Milord, 2 examples.
Which is this? Which is your SLP?
Milord, my SLP number is 17.6. It is, Milord. Milord, I have an 20729 of 24. 20,729 of 24 is my SLP number, diary number. SLP.
Covers totally 367 persons.
367%.
Where they were appointed earlier, much prior to this 270. They participated in this and they were given continuity of service.
744 is somebody who was appointed in 1999. 744, I have given that, shown that, I can show that example. At serial number 131. And he is due to retire next year. So he was appointed, Milord, on 8/3/1999. And he is due to retire now. So, Milord, these are, I am representing those set. Now, Milord, we got notice of this in November 23 before the High Court. We filed 2 applications before the High Court. That applications are taken note of, but no orders are passed. If your Lordship would like to see that paragraph, it is in paragraph, my Lord, page 154, paragraph number, my Lord, 108. This is all that is stated. We have got annexed the copies of these applications also, with ours especially. But I am showing this paragraph of the judgment from the main first paper, the State of West Bengal paper.
Yes.
So they only note that these applications have been filed. Application CA number 23 and 24 was ours. And if your Lordship would like to see the particular application, I have put them in my SLP.
Mr. Shubhro Prakash Lahiri.
Lordship, please. Shubhro Prakash Lahiri was our advocate there. We got notice, my Lord, your Lordship will see the third last line of that para. That notice was December 6, 2023.
But you never said that, well, if this is cancelled, allow us to retain our lien on our earlier employment.
So, my Lord, I am putting it this way, my Lord.
Your case was of segregation.
Yes, and I am nowhere in any CBI list. In any list, my Lord, I am not there. I have been given continuous.
That will come back after lunch.
Much obliged.
This player was never.
Lords, that gaming matters 8 and 20.
Yeah.
The nodal council has also sent an email. Mr. Venkatraman is here. We're wondering if you can take it in July.
We've
Okay.
requested
We've
for a
requested.
15 July date.
Well, that because today we won't be able to.
Yes.
Yeah, today unlikely.
We've sent an email requesting the date also.
For 8 and 20 needs to be formally tagged with item 8.
Okay.
And then
But 15th is a Monday.
Yes, my lords. Please, because there are some, if it can be at least kept that date.
no, any date.
then-
Your Lord.
All right, we'll keep it on the 15th and then we can
Yeah, very
find a date and get.
That's what.
Grateful.
Grateful.